Make sure to give my dad a 5-star review.
Make sure to like and subscribe to his YouTube. Thank you for listening and enjoy the show.
You know, I think if we're going to thrive for the next 250 years, we've really got to recapture that spirit of 1776, the spirit of 76. There was a hope and a yearning for freedom at that time, for Americans to move forward as Americans united. And Christian nationalism, the lie that America was founded as a white Christian nation, it's really incompatible with that spirit. Religion divided the colonies and the colonists. And when it came time to unify under the banner of the Constitution, they set aside a government that enforced church doctrine in favor of a government that separated church and state. And I mean, that ideal, it's clear and it's reflected in the name of the new country, right? The United States of America.
Hey, welcome back to Church and State 250, a series from Faithful Politics where we examine how faith has shaped America from the founding to today. I'm your political host, Will Wright, and I'm joined by your faithful host, Pastor Josh Burtram. And in this episode, we are going to focus on the legal side of church-state issues. If you've been following the series, you've probably heard a lot from our previous guests about religious tests, maybe Establishment Clause, but you've heard all of that from a historical perspective. In this episode, we're looking to look at those ideas, but applied through the lens of law and kind of how it shaped religion throughout public life. And to do that, we're joined by Andrew Seidel. He's a constitutional attorney who has spent years working on church-state issues and tracking how these cases actually play out in real time. He's the author of The Founding Myth and very excellent American Crusade, not to be confused with the book by the Secretary of Defense currently. And he's also been...
My book is opposed to the American Crusade.
Yeah. Yours the like American...
Whereas his is trying to create an American Crusade.
Yes. And Andrew's book is trying to explain what the American Crusade is, and he's been doing that by, just being involved in all kinds of legal efforts that are trying to protect religious liberty from all faiths. So today we're just so glad to have him back on the show to help us do that. So welcome back to the show, Andrew.
It is my absolute pleasure.
Yeah. Well, I know I didn't really do you much justice in that intro. So I'd love for you just to maybe expand on that a little bit about who you are and what you do and why you do it.
Sure. I'm a constitutional attorney. I litigated these cases in court for a very long time, realized that attorneys tend not to be the best communicators about these issues and that we are fighting a misinformation machine. So I kind of moved out of the court of law and into the court of public opinion, started writing more books, doing more op-eds, more public speaking. I have edited a textbook for law students, Law and Religion. I mean, this is what I do. It's what I love. And the reason that I do it is because the separation of church and state protects everybody. And when we do a good job of separating church and state, everybody wins and everybody is freer. And, one of the things my mom always taught me was, when I was growing up, was to stand up to bullies. And a lot of what I see in this space is people who are just abusing their power, the power of a temporary office that they occupy to impose their religion on other people. And that, in my mind, is just another form of bullying.
Yeah, a lot of your work also revolves around religious liberty, religious freedom.
Oh, yeah.
And I'd love for you just to kind of maybe help us understand that. So, I'll give you a for instance. And this is a for instance I just recently read in your book, American Crusade, again. So if part of my religious tradition is I'm a Bible-believing Christian, that story of Abraham sacrificing his son really, really impacted me. And I'm like, that is how I am going to choose to live out my faith, is I'm going to make a sacrifice. Is that, once the cops stop me, obviously, could a defense be, I am just practicing my constitutional right of religious expression?
It could be, and we've seen versions of that in the past. There's a professor of church-state separation, religious freedom named Makin. He once observed that at the bottom of every slippery slope involving religious liberty is human sacrifice. And what he means by that is that this example is really, really powerful. This example of, does your religious freedom include the right to kill another human being, right? And Thomas Jefferson actually used this as an example when he was writing about this back at the founding. The Supreme Court used this as an example in the 1800s. And everybody uses it as an example to say, no, right? Your religious freedom is a limited right. It does not allow you, the believer, whatever it is that you believe, to violate the rights of somebody else. So everybody listening has probably heard the old legal adage that your right to, swing your fist ends at the other person's nose. Well, your right to exercise your religious freedom ends where the rights of other people begin. And this is a really, really simple and basic line. This has been our understanding of religious freedom since the founding, that your religion is not a license to violate the rights of others, ever. And that is what we have seen the Supreme Court turning on its head over the last 10 to 20 years, what I refer to as the American Crusade in that book. And to put a finer point on your question, we do see folks invoking this defense when they, for instance, do not take their child to get health care. Something as simple as an insulin shot, or there's some conditions that children are born with that literally require a doctor to shine a light on the child for a little while. It's a very long word that I can't pronounce and won't even try to, but you have parents who do not believe in getting their children medical care, and the kids die as a result. Do they have a right to impose that belief on that innocent child? Do parents have a right to beat a child because they believe their Bible says in Proverbs 13, spare the rod, spoil the child, that kind of thing? So we do see these questions pop up in the law, and we do see religious freedom argued as a license to harm others, but that is not the way it should be. That is not the way it ever should be.
So yeah, I was appreciating what you're saying there, Andrew, and it brings up to me this idea. And I grew up in a Christian home, definitely still a Christian, and we had spanking, right? You just mentioned spare the rod, spoil the child, right? And this kind of almost gray area of spanking. Now, of course, I think certain people are like, hey, if someone's beating a child, right, mercilessly beating, or even not even just using something that's inflicting harm. I totally understand how people are looking at it. They're like, no, that's not good. And yet then sometimes though people are like, well, they're doing it in order not to create harm, or they only do it in instances where they might harm themselves, like someone slapping a child's hand, in order to keep them from touching something that's going to be hot or something like that, or physically, doing something that's going to take them out of harm. And the only reason I'm bringing this up is just thinking about how these gray areas come when it comes to religious freedom. And some people might not think it's a gray area, other people do. And really the question though, you're welcome to speak on that, but the question I have is, right, we have this establishment clause that's supposed to keep the government from establishing a certain religion that it is then enforcing on its populace. What can you kind of help us understand from a legal standpoint what that was set out to do?
Oh, yeah.
And then how it shaped the role of religion and especially Christianity in our public life. And then, yeah, I would just love to kind of hear your thoughts on that.
Yeah, I mean, you're going to wind me up, and I'm going to go for a while on that one. I will touch briefly on your previous point too, which is I think the gray issue that you're identifying, or the gray area you're identifying there, is actually the fact that parents also have a duty to raise their children, right? And parents have certain rights and responsibilities, and one might say power over their children. I think we have responsibilities as parents to the kids as well, but I think that's actually the conflict you're identifying. You can take simpler examples too. One of the ones that I include in American Crusade is two Mormons who come to your door and want to try to convert you to they've got this book with all this amazing news, and then they refuse to leave when you say no thank you, right? They are exercising their religious freedom by trying to convert people. Their God tells them to do that, but you have a property right and interest to say, hey, you have to get off. Their religious freedom doesn't trump your property, right? So you can take simpler examples that kind of take that parent-child difference out. And I get into all of this in American Crusade, and it's so fascinating. But let's dive into the Establishment Clause and the separation of church and state. And I want to do what lawyers love to do, which is object a little bit to the question, because I think there's a common misconception when it comes to the separation of church and state and when it comes to religious freedom that it's only the Establishment Clause of the Constitution that's important. But that's not right, because the separation of church and state is so much bigger than that. So for people who are listening who are like their eyes are glazing over, the Establishment Clause is the first few words of the First Amendment, which begins, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Those are the two religion clauses. The first part is the Establishment Clause. The second part is the Free Exercise Clause. But Americans have to understand that the separation of church and state is so much bigger than those 10 simple words of the Establishment Clause, that it's bigger than even both religion clauses, bigger than the First Amendment. If you look at our Constitution, most of the truly original and unique elements of that Constitution are secular, right? So our Constitution was the first to declare that power comes from people, not gods. So those words that are big and bold right at the beginning, we the people, they're poetic, but there's so much more. They are a declaration of power. Self-government is impossible if power flows from the divine, but it's natural when power flows from the people. Our Constitution was the first governing document not to mention a god or a deity. It's godless by choice, not by accident. And there were actually people in the founding generation who objected to that choice. And there have been movements across U.S. history to add to the preamble of that Constitution, to add to we the people, Jesus, and to minimize the people. None of those have succeeded. Our Constitution was also the first to ban religious tests for public office, and this is in Article 6. And that's actually the only mention of religion in the original unamended document. And that ban on religious tests is some of the most clear and emphatic language in a document that's often deliberately vague. It says, no religious test shall ever be required as a qualification to any office or public trust. No, shall, ever, any, right? Those are clear commands. And one of the earliest judicial scholars that we had, Justice Story, wrote a book called The Commentaries on the Constitution. And he told us that this clause, quote, had a higher object to cut off forever any pretense of any alliance between church and state in the national government. But even all of that was still not enough. The founders wanted more. And so then you get that First Amendment, which protects 6 rights: a secular government, religious freedom, speech, press, assembly, and petition. All of those bolstering our right to think freely. And that's what it is about at the core. And there is a legal movement that is attached to Christian nationalism that has, over the last 50 years, really reduced the sole functional text separating church and state to that little bit, that Establishment Clause. But that's not where it lies. It is woven into the fabric of our Constitution. And I really think we need to expand our popular understanding of this principle if we're going to save it.
Stay with us. We'll be right back.
Women were vital to the history of American Christianity. But now growing numbers of women are quitting the church over misogyny, abuse, racism, homophobia, and the big banner that seems to connect it all, Christian nationalism. I'm Sarah Stancorp, and my new book, Damned If She Does, is about why millions of American women have quit church and what it means for the future. Keep listening at the end of this episode for an exclusive Faithful Politics sneak peek.
You know, talking to Warren Throckmorton and about like the role of the Anti-Federalists, right? So the Anti-Federalists were not very keen on the idea of no religious tests. A lot of the colonies kind of had that. Over time and generations, the state started to disestablish from religion as well. And then it seemed as if there was this period where, like, this is probably going to be a terrible analogy, but like that period between the Old Testament and New Testament, I forgot what that place is called.
An intermission, we'll just call it.
Yeah, we'll go with that one. But it seems like there was a quiet period where there wasn't a lot of action challenging the law up until, I believe it's Everson. So I'd love for you to kind of just help us understand, sort of the legal landscape that kind of helped, get the Establishment Clause back into sort of like the court system.
Sure. So Everson is one of the first times in the modern era where the Supreme Court really delves into the separation of church and state and religious freedom. And this is in 1947. You could argue, 1943, there was a case called Barnett. It's a really famous case about Jehovah's Witnesses challenging the forced standing for the Pledge of Allegiance and recitation of that pledge successfully. There's another case in the 1870s, Reynolds v. U.S., where they kind of grapple with these things. But Everson kind of kicks off the modern era, and there's a lot of cases that come right on its heels. It was more important for what the court said than what the court did. The court applies those First Amendment protections that you were just mentioning to actions by the states. So New Jersey in that case. This is a legal process that we call incorporation. We don't need to get into the weeds on it. But basically, the first word of the First Amendment is Congress, right? So it is applying to the federal government. And in this case, we have the court saying, hey, this is also applying to the states. It was a 5-4 decision which upheld public money, taxpayer dollars, reimbursing families for transportation costs that they incurred for sending their children to religious schools. So I think that's the wrong result. But all 9 justices in the case, even though it was a 5-4 split, a close case, they all agree with a very broad interpretation of church-state separation. It's just that the 4 dissenters thought that the reimbursements violated that separation. So you have that entire court agreeing with the idea of a very strict and robust separation of church and state, agreeing with, and here's a quote, "The First Amendment has erected a wall between church and state. That wall must be kept high and impregnable. We could not approve of the slightest breach." And the court goes on to say, again, all 9 justices agree with that sentiment, with these broader sentiments. It goes on to explore what it really means and what the establishment of religion really means. And it's that neither a state nor a federal government can set up a church. Neither can pass laws which aid one religion, aid all religions, or prefer one religion over another. Neither can force nor influence a person to go or to remain away from church against his will, or force him to profess a belief or disbelief in religion. No, they can't tax people. And they go on. It's this really, really, really great paragraph about what the government cannot do. And this had a pretty remarkable impact on our public institutions. There's 2 really big things kind of that came out of this, because a few years after you get Everson, a few years later you get Brown versus Board of Education. And taken together, Everson and Brown versus Board, effectively mandated that public schools are going to be open and welcoming to all people, regardless of religion, regardless of race. And that was a big deal. No longer could these schools, which were often captured locally, be used to impose or propagate a white Christian nationalist vision of America. That's probably why you have people like Jerry Falwell writing back in 1979, that he hoped to see the day when we don't have public schools. The churches will take them over and Christians will be running them. And the second big thing to come out of Everson, to my mind, perhaps the most important change, was that after the Everson decision, because there was all this really great language, and the court had espoused this principle really nicely but failed to uphold it, a group of clergy actually came together and they formed a group that's dedicated to defending the separation of church and state. And today, Americans United for Separation of Church and State, the organization I work for, continues that 80-year legacy of fighting for freedom without favor and equality without exception.
Wow, that really is remarkable. It's really cool to hear that connection history.
Before you say anything, Josh, I just have to applaud Andrew with this expert level plug for America.
That was pretty good. That was pretty good. I gotta say.
Thank you. I appreciate it, gents. I appreciate it.
I mean, that was expert, dude. I definitely you were cooking and you got me. I was like, oh snap! You took me where I didn't think I was gonna go. It's like what they used to tell me about the devil, but you're not. He's gonna take you further than you ever thought you would go, and keep you longer than you thought you'd be there. But you're not the devil. Don't worry.
I've been called it.
I'm sure you've been called the devil, but I've been called the devil too, Andrew. So, and I'm like an evangelical or was whatever. People just think I'm woke, crazy, everything now. So it doesn't matter. But I did want to think about though Brown v. Board of Education, dig into that a little bit more because obviously that's a huge case that many people know about, right? More so than Everson, right? V. Board of Education.
Yes,
so it's like.
Sure.
Well, a couple of things. Like one, what's up with the Board of Education in all these cases? I looked it up, like 50 plus cases have a Board of Education or something. And I'd love to hear your idea. Like, I mean, it kind of makes sense, but I'd love to hear from a lawyer why you think the school systems are such a ripe, place for constitutional fights. And then, but what happened with that? Because that wasn't religious explicitly, or was it, right? What was the effects on religion, separation of church and state through Brown v. Board of Education?
Yeah. I mean, your first question is really interesting. And I mean, I think there's two elements to it. Why we see more of these cases pop up regarding schools and public schools in particular, because that's where, those are the schools that the First Amendment applies to. And I think it's because that's our kids, man. It really brings home how gross a violation of our individual rights it is when you have politicians imposing their religion on your kid. Politicians saying they know what is best for the religious upbringing of your child. One of the first religious freedom laws we have, the Virginia Statute for Religious Freedom, that Thomas Jefferson wrote and that James Madison shepherded through the Virginia legislature. He talks about the impious presumption of legislators who are themselves but fallible men to impose their particular narrow set of beliefs on everybody else. And that's why I think you see so many of these cases in public schools. And that's we're fighting a lot of these battles about the 10 Commandments in public schools right now. And I think people don't realize our plaintiffs there are parents. And they're often clergy. They're so many of the parents that we are representing against these school districts in Texas and Louisiana and Arkansas are clergy whose kids are in public school, and they don't want politicians. They don't want Greg Abbott deciding how their child should worship, when their child should be told that this is the God that you are going to worship, and when and how and all. I mean, it is an impious presumption, but I think that's why. It's because it's our kids. And it's also the reason that even though we're seeing the erosion of the separation of church and state, often in the name of religious liberty these days, that the schools are kind of the last bastion of that separation of church and state. So, I mean, that would be my 2 cents. And I can this actually really, I don't know if I've ever told this story publicly before, but when my kid was one of my kids was going into pre-K, the school district here put him into a pre-K program at the local Catholic school. And, I got the full experience of being a parent who was all of a sudden going to have their child going to what is supposed to be this welcoming public school in a Catholic school where they have prayers on the classroom wall. They have crucifixes in the classroom where, they have a 3-foot tall crucifix in the classroom. I am going to have to explain to my child why there's this image of a person being executed in his classroom, right? That is not up to our government to force that conversation onto parents, to force that religion onto kids. And it's a violation of everybody's religious freedom. So that's I think, a long-winded answer. I'm getting myself fired up about that one.
Brown.
Yeah. Yes.
If you could talk about the Brown v. Board of Education, because I'm curious about this too, because when we think about Brown, I don't think that most people think of Brown v. Board of Education as a religious case, and probably superficially it's not, but downstream it had a lot of influence on some of the things we see today, especially in the context of charter schools, school choice stuff.
I mean, I think that's the biggest impact that Brown had on it, is because it said that these public schools have to be open and welcoming to all and taken together, right? Everson and Brown say that religion doesn't matter, race doesn't matter. This is going to be an institution that is open to everybody. The backlash against Brown versus Board of Education is where you can really see the impact. And it goes to what you were just talking about. The first time that private school vouchers are created is in response to Brown versus Board of Education. And vouchers were created to maintain segregated schools. The idea was fine if the Supreme Court says we have to have black and white kids learning next to each other, we're going to get all the white kids into private Christian schools, and vouchers are the way that we are going to do it. And this is a complicated and convoluted story that I try to really simplify in American Crusade in the chapter on this. But it was the attack on public education that we see today through vouchers and the private school movement really was a response to Brown versus Board of Education and the attempt to desegregate schools. And there's also a flip side to this too, which is that I think a lot of people don't realize, which is that one of the seminal cases in church-state separation, Lemon versus Kurtzman, was actually a case about both religion and race. And by the time it got to the Supreme Court, it actually had shed the racial component, in part because of all of this kind of other stuff that was floating around. The court was like, well, maybe we can just deal with just the religion aspect of this, and it will actually be a little bit less controversial. But it was really a challenge to a Pennsylvania law that propped up religious schools with taxpayer money. And because it was propping up those religious schools, it was keeping education segregated in Pennsylvania. So there's often these fascinating overlaps between these two areas that people are just not familiar with. And to be honest, we public scholars have not done a good enough job of educating folks about.
Since you brought up Lemon v. Kurtzman, this is actually a good segue to kind of take us from that period in history to more current.
Yeah.
So if you can just maybe talk about, the lemon test, which came out of Lemon v. Kurtzman,
Sure.
and then, sort of its applicability use over time up until Kennedy v. Bremerton School District.
Sure. Oh, the lemon test. So lovely, so simple, so maligned. So the lemon test comes from that 1971 Supreme Court case, Lemon versus Kurtzman, that was about money flowing to private religious schools that were segregated. And in that case, the court comes up with this test that we later called the lemon test. They didn't say that at the time. But what the court was really doing was it was looking back on all of the other cases where it had looked at the collision of religion and the law and church-state separation, all that. So, Engel versus Vitale, Abingdon v. Schempp, all of the cases that came before. And it synthesizes from those cases all of the legal principles that are important to the court when it's trying to decide these questions. And I'll lay it out in a second. I just want to, there's nothing wrong with the lemon test. The problem with the lemon test has always been the court's unwillingness to apply that simple legal principle when a politically unpopular remedy might be required as the outcome, right? So again, the case underlying this, money is flowing to private religious schools that were segregated. There's this guy named Alton Lemon. He's a really fascinating guy. He served in the Army, graduated from Morehouse College with a degree in math, I believe it was. This is a guy who played basketball with Martin Luther King. He was a government employee. He was a black humanist. And Pennsylvania has this law on the books that is essentially propping up religious schools with taxpayer money. So the way it would work, it was a little convoluted, but the state would pay for teachers to teach at religious schools if they weren't teaching a religion class. So it's kind of like vouchers for teachers' salaries instead of student tuition. And the state had paid out like $5 million by the time Alton Lemon challenged the program. And it got combined with another similar case out of Rhode Island by the time it made it to the Supreme Court. But Lemon argues that these schools are segregated by race and by religion. And so that this whole program promotes segregation. That's what he was arguing against. And that it was forcing, two school systems into Pennsylvania, a public school system that was poor and black and a predominantly white, affluent, superior, in his words, school system. And the Supreme Court strikes down this program as a violation of separation of church and state. And again, it surveys all of the cases it has decided and synthesizes this simple test. And basically it says, here's what we're going to do when we get presented with one of these questions or one of these cases. We're going to ask these questions. Does the challenged government action, one, does it have a secular purpose? Right? Are we doing this for a good secular reason? Two, does it have a primary effect that neither advances nor inhibits religion? And the third is, does this government action foster excessive entanglement with religion? And if the government action fails on any one of those three prongs, it violates the Constitution. Right? And one of the things that I think is really important for everybody to understand is that the justices in this case explained that striking down that program and instituting this test enhances religious freedom because it separates church and state. So they write that when taxpayers of many faiths are required to contribute money for the propagation of one faith, the free exercise clause of the Constitution is infringed. And this was a case it was really strong precedent. It was older than Roe versus Wade. It was an 8-1 decision that, again, built on all of these earlier cases. And that's it. That's the Lemon test. It's simple. It's elegant. But if it were applied to the cases that started coming before the courts, they'd have to start making these possibly politically unpopular decisions. So almost right away, you get the courts and judges looking for ways to avoid using this test. And the court even admits this later on, and they say, so it's, quote, rather than mechanically invalidating all government conduct or statutes that confer benefits or give special recognition to religion, we're just gonna not. And the Lemon test became, or if you enforce the Lemon test, it became that tall, strong, impregnable wall of separation between church and state. And that is a huge barrier to Christian nationalism, because the separation for church and state is the cure for white Christian nationalism. White Christian nationalists can't achieve their ultimate goal when that wall is tall and strong and impregnable. So they've been tearing it down so that they can assert their supremacy. And too many Americans have been letting them. So again, that was the only thing Lemon did. It was preventing the rise of white Christian nationalism in our government and government institutions. So
and it's no longer really in service because of Kennedy, right?
I mean, it's not a coincidence that as it has been weakened, that white Christian nationalism has been strengthened. And the justices on the Supreme Court in case after case have been taking pot shots at Lemon. And in Kennedy, there is language in there saying, that essentially that they retired Lemon. They use kind of various different phrases to describe it without ever outright overruling it, which is an interesting choice on their part.
Yeah, that is an interesting choice. But I would love to talk about even more depth the Kennedy v. Bremerton and even Carson v. Makin, trying to understand what happened there and then how did it dismantle the Lemon test, essentially.
Yeah. I mean, the last question is easier because the justices can write what they want in their opinions. And if they say that this is no longer case law that you can use lower court judges, then lower court judges have to obey. They don't even have to have a reason. They're supposed to, but they don't really have to. But I mean, the Kennedy case is fascinating and terrifying in a number of respects. So In that case, and everybody who's listening has heard about it, the court ignored the religious freedom of students and families and allowed a coach, football coach at a public school, to impose his personal religion on other people's children. That's what happened in the decision. And if you're like, well, I didn't hear about that, or that's not what I remember. The reason you don't maybe recognize that case is because the Supreme Court majority in a lot of these cases lately is spreading disinformation. If, for instance, if you've only read the Supreme Court's opinion in that case, my description may be confusing. But I can tell you, having been involved in that case actually from the beginning, which started back in 2015, and as someone who's been involved in more than a few of these cases for years and years on end, I can tell you that Supreme Court justices are really unreliable recounters of history and fact, to the point where I wonder if they live in a shared reality with us. And so let me give you an example from the Kennedy versus Bremerton case. And let me just pull up this because this is so worth reading aloud. One of the judges on the Ninth Circuit warned, so the Ninth Circuit's the court below the Supreme Court, warned that First Liberty Institute, which was the Christian nationalist group that was behind the case, was spinning a, quote, false and, quote, deceitful narrative in that case. Okay, those are very strong words coming from a federal judge. So Judge Milan Smith wrote, and this is in an opinion, quote, unlike Odysseus, who was able to resist the seductive song of the sirens by being tied to a mast and having his shipmates stop their ears with beeswax, our colleague, Judge O'Scanlan, appears to have succumbed to the siren song of a deceitful narrative of this case, spun by First Liberty, to the effect that Joe Kennedy, a Bremerton High School football coach, was disciplined for holding silent private prayers. That narrative is false. Smith goes on to add that the reader should know the following basic truth. Kennedy was never disciplined. The judge actually, in his opinion, this is crazy. I've never seen anything like this. He compares those deceitful the deceitful narratives, quote, unmoored claims, his words, side by side with reality in a chart. Again, I've never seen something like that in an opinion. And if you are a lawyer out there, if you're any kind of professional, just try to pause here and imagine that you are litigating a case and that federal judges are writing this about your work. Deceitful, unmoored, false. Like if a judge was writing that about me, I would hide my head in shame. I would take a sabbatical. I would question what I was doing with. Maybe I would read up on some moral philosophy, maybe take an ethics class. Instead, First Liberty Institute appeals that deceitful narrative right to the Supreme Court. They regurgitate that same false and deceitful narrative. And it's really worth thinking about that, thinking about how confident they must have been that this deceitful narrative would fall on friendly ears. And the worst part is they were right, to the point where Justice Sotomayor was just so exasperated with the lies that in the dissent of her case, she puts in photographs that show this coach imposing his prayer on other people's kids on the field. Right? There's multiple photographs in the dissent of this coach praying with kids. These are kids who felt, we know because they wrote about it, they felt that they had to pray if they wanted to play. And in no world is that religious freedom. That is coercion. And just one more note on this because it gets even worse. A full year and a half before the Supreme Court, or before First Liberty Institute asked the Supreme Court to take the case, the coach and his wife sold their house in Washington State and moved all the way across the country to Florida. And that actually should have ended the case because the only relief that the coach was seeking was reinstatement as coach. And I don't think a 2,800-mile commute for a $4,500 seasonal job is a realistic possibility. But the Institute didn't tell the court, didn't tell the parties. This came out after the court had accepted its case. So that they shouldn't have taken it, but they wanted to. And if you're wondering, no, he, of course, did not, after winning this case before the Supreme Court, he didn't keep the job. He flew up for one game and then quit. And the core aspect here of this case is that the conservative justices ignore the existence and rights of everyone in the case except for this Christian coach. And that is the only way they can get away with this kind of outcome. Because the moment you recognize this as a coach at a public school, holding public office essentially, imposing his religion on other people's children, is the moment his freedom is limited. And so the court just pretended those kids didn't exist for the most part. And that's essentially what happened in the Carson versus Makin case. That's the same basic idea. The court ignores the religious freedom of everyone to focus on Christians who are claiming religious freedom. And in that case, it was a right to tax citizens and force them to pay for Christian schools that indoctrinate kids and discriminate against people that are different, which, if you've been paying attention, has come up in several of the cases we've already talked about, right? And this is one of the core ideals of religious freedom and church-state separation from the founding all the way to now, that the coercive taxing power of the government will not be wielded to take money out of your pocket and give it to a religion that is not your own, right? That's government-enforced tithing. That's precisely why that Virginia statute that I mentioned was drafted and passed. Thomas Jefferson called it sinful and tyrannical to do that. There's nothing more un-American than that, and the Supreme Court has been rubber stamping it in case after case after case, including Carson versus Makin.
You know, the Kennedy v. Bremerton case, that one got on my radar because I'm from Bremerton. Actually,
really?
Yeah, I lived about 2 blocks away from the high school, and
no kidding.
Yeah, and so when it came out, we had Brian Kaler and Amanda Tyler on to kind of break down the case. So if you're watching and you want more details of it, we spent the entire episode just talking about the case. But it seems like, to me, each Supreme Court case just takes a little bit of the wall.
Yeah.
It just seems like it just takes a little chip away. And I'm curious to kind of get your thoughts about why is the courts so important?
Oh.
I mean, was there something about, Everson, where they're like, hey, wait a minute, we can live or die by what the courts say, or is there some other reason? Just love to get your thoughts on that.
Man, yeah, I think that is a really insightful question. I think, the why there is so important. And it actually answers the question. Some people might be like, how is it even possible that in Kennedy, the court bungled this so badly? How could they possibly ignore judges who screaming about a deceitful narrative and talking about the sirens? And the answer to the question is the same. There is a movement out there that is deliberately trying to advance white Christian nationalism. And the guy who does this on the legal front is a guy named Leonard Leo. And Leonard Leo and the conservative legal movement set out to capture and pack our courts because they could not win otherwise. There was no other way for them to actively achieve their policy aims. And there was a former employee of Leonard Leo's who actually, he lays this out. He says the quiet part out loud. He says, Leonard Leo, quote, figured out 20 years ago that conservatives had lost the culture war. Abortion, gay rights, contraception, conservatives didn't have a chance if public opinion prevailed. So they needed to stack the courts. And that's what they did. And it's really the reason that quote is so telling. I mean, just pay attention to the anti-democratic admission and goal that is right there, right? If they don't stack the court, the majority is going to rule. Democracy is going to work. And it's because public opinion is against them on almost all of these things, 70, 80%, whether you're talking about abortion or gay rights or contraception or putting the 10 Commandments on the wall or a coach imposing his religion on other people's kids. I mean, even in Texas and in Oklahoma, the support for the separation of church and state is in the 70s and 80s at the low end, according to some internal polling that we've done. So if they don't capture the courts, democracy is going to work, and they're not going to be able to impose their religion on others. They're not going to be able to advance white Christian nationalism. And so Leonard Leo is the guy who orchestrates this capture. Part of his job, he was described as the, quote, monitor of the nominee's ideological purity. Just think about that. The monitor of the nominee's ideological purity. That's talking about the judicial nominees. And all told, he's responsible for the confirmation of Roberts, Alito, Gorsuch, Kavanaugh, and Barrett to the Supreme Court. Thomas is an old friend of his. There's actually video of Thomas and Leonard Leo joking on stage about how Leo's the third most powerful man in America. All 6 of those justices are or were members of the Federalist Society, which Leo helped run for 25 years. So, that's 6 votes on the Supreme Court, and Leo personally chose 5 of them for their ideological purity. And I know this veers into sounding, conspiracy minded. So I want to bring some numbers to bear on this, because we know which groups Leonard Leo funds and runs. And we know that overall, his group spent $580 million, $580 million, packing the court from 2014 to 2020. And they're not spending that kind of money to get an impartial court. They bought a court. They captured one branch of the federal government for about $500 million. Right? And they weren't doing it, again, to get judges who would decide cases impartially, but to buy results, to buy wins. And it worked. And there have been studies that crunch the numbers. And before Leo packed the courts, the court ruled in favor of religion about half the time. And that is exactly what you would expect, right? You flip a coin 50-50. That's about how often religion would win at the Supreme Court. But under Roberts, that win rate jumps to 81%. And this is not a pro-religion, it's a pro-Christian shift, because mainstream Christianity used to be favored in about 44% of the cases, and under Roberts, that goes up to 85% of the cases. Now, those numbers were only up through 2020, and in April of 2026, the Washington Post actually commissioned a report from some of these same scholars to look at the last 5 terms, and it's even worse. It's even more shocking now. The court voted in favor of parties asserting religious rights 98% of the time. So they targeted the courts because they don't want democracy to work, and this is the way that they can impose on everybody else. And again, they're winning these cases not because they're good lawyers, it's because the court was captured. The Supreme Court runs on white Christian nationalism.
Man, that's a lot.
It is.
That's a lot.
It is.
And there's so many questions I have, but I want to, just for the sake of our 250, I want to keep in to the segment and just kind of ask this, like, how do you think this has shaped Christianity itself? Right. So we see how the courts, and just, I'm not asking to speak on, your personal faith or lack thereof, but more about where, from your perspective and your area of expertise, how has this trend shaped Christianity rather than this just Christianity shaping the court, if that makes sense? Yeah.
It's a really interesting question. And there's a question that bounces around in sort of the scholarly circles with religious freedom cases, and a bunch of the people you're going to talk to for this pod series you're doing. And it's, does religion influence politics, or does politics influence religion? And I think it's hard to pin down. It's sort of the snake eating its tail. It's hard to know which does what, or the Mobius strip. You don't really know, and it's certainly a feedback loop where they feed each other. But I think there are cases where you can see politics driving religion, and to me, there's a very clear recent example, and that's the pandemic. Right? During the pandemic, we had essentially a government that could have done a significantly better job responding, and the response to the pandemic became politicized. And the longer it wore on, the more it became a political issue. And after that happened, after it became kind of a political issue, it turned into a religious issue. And you started seeing cases being brought asserting religious freedom challenges to public health orders. And those challenges all failed. None of them succeeded because, again, your religious freedom isn't a right to risk the health and safety of an entire community. Right? You do not have the right to impose your religion on others. You don't have the right to risk their health, their safety, certainly stress hospitals, things like that. And so they failed until Trump got Amy Coney Barrett onto the Supreme Court. And that change in personnel changed the law. And it actually, then you see all of a sudden these religious freedom cases against public health orders, they're winning. And by the way, just fun aside, there were a bunch of other First Amendment challenges against those same public health orders, free speech, free assembly, things like that. And none of those succeeded, even after Amy Coney Barrett. Religious freedom is special in the eyes of this court. But the point I really want to make is there wasn't some like new Dead Sea Scroll that was discovered that said, you masks are bad and you can't force me to wear them. But there were new religious beliefs that were asserted as divine and as entitled to special protection under the law as a way to challenge those elements those public health orders in the pandemic. And to me, it was a really striking example of politics turning around and influencing religion in this country that we got to see kind of happen in real time and in our life. I mean, and I think the flip side of that, to kind of to answer your question a little more finely, is one of the reasons that, I am not a believer, but I am working at an organization that is made up of all kinds of people, believers of all different stripes. We have supporters, about half of them are non-religious, half of them are religious. I'm going to the Summit for Religious Freedom this weekend, and it's going to be about the same kind of breakdown. I'm doing a panel with a whole bunch of different Christians on it. And everybody is coming together to fight for true religious freedom and to fight for that separation of church and state, which is the only thing that guarantees that religious freedom. And we are seeing, with this rise of white Christian nationalism, a lot of folks are realizing that shared values matter more than shared beliefs. And we are seeing a lot more people organizing around those shared values to fight for a country where the separation of church and state will be valued by everyone, where our democracy will survive, coming together to organize around that set of shared values. And I think that's because America will never be a Christian nation, because the moment it becomes a Christian nation, it will cease to be America. Those two things they can't peacefully coexist. One of them is going to triumph. And that's the question I think we need to ask ourselves on the 250th. That's the the choice that we face as a nation, right? Christian nationalism or America, because we cannot have both.
Yeah, that's pretty heavy and appreciate that, Andrew. Well, one question we're asking all of our guests, because it is, America 250 and for the series, just for those that are curious and why there's a plus sign, it's 250 plus years of faith in America because I think a lot of the focus for July is going to be 250 years America's founding. But, the reality is that there was an America before, 250 years. So I'd love for you just to kind of reflect on America's 250, especially given sort of your work on church-state separation, and what do you see as the future of church-state separation?
I think if we're going to thrive for the next 250 years, we've really got to recapture that spirit of 1776, the spirit of 76. There was a hope and a yearning for freedom at that time, for Americans to move forward as Americans united. And Christian nationalism, the lie that America was founded as a white Christian nation, it's really incompatible with that spirit. Religion divided the colonies and the colonists. And when it came time to unify under the banner of the Constitution, they set aside a government that enforced church doctrine in favor of a government that separated church and state. And I mean, that ideal, it's clear, and it's reflected in the name of the new country, right? The United States of America. And I'm so proud to work at Americans United and carry that torch and defending that principle as Americans United. And I think we can and should proudly celebrate 250 plus years of American independence from kings who ruled over both church and state. It was a bold and a brave idea to cut off ties with quote, the Christian king of Great Britain, as an early draft of the Declaration explained, and to set out on that journey to create a new country that was free from divine monarchy, from theocracy, and instead is of the people, by the people, and for the people. Yeah, we've never been perfect, but for 250 years we've been marching towards the promise of America as a country where all people can be free. And I do think that means fighting Christian nationalism, because they threaten the promise of freedom and hope to turn us back to those dark times before 1776, when religious oppression was rampant and rulers were free to impose their personal religion on subjects. And not on my watch.
That's awesome. Well, thank you so much, Andrew, for spending some time with us and just for the work you do.
Pleasure on both counts.
I'm so blessed, and
thank you.
Thank you to our audience again for stopping by. This is the Church State 250 series. If you haven't already, make sure you stick around and watch some of our other interviews that we've got coming up. We've got, who do we have? We got Sam Perry and Andrew Whitehead together. Let's talk about Christian nationalism and, just some other folks that I think you'll really, really enjoy it. Make sure you stick around. And then, as always, keep your conversations not right or left, but up. And we'll see you next time. Take care. See ya. Hey, welcome back to Faithful Politics, and for our brief little interview with the one and only Sarah Stancorp. How's it going, Sarah?
Good. It's going well. Thanks for doing this.
Oh, so at this year's Southern Baptist Convention, and I'm no expert, but I can read the news, they voted overwhelmingly to advance some sort of formal ban on churches with women pastors. And your book, Damned If She Does, looks at why women are leaving the church and what that means for the future of religion. So I'd love for you just to, maybe give us what's one story that helps explain how a decision like what happened at the SBC shouldn't really surprise anybody.
So when I had the idea to write this book probably over a decade ago, I thought it would be very contemporary and how now we're decades hence. And when I sat down to write the book, I realized I actually needed to start in the 1980s because a lot of the threads that became important in women's lives started then. And I know this mini interview may become part of a broader conversation on Christian nationalism. As I look at the way evangelicalism, how the Christian right has embedded itself with our politics and really turned into a Christian nationalist machine, a big piece of that is Christian patriarchy. The way women are oppressed within this system is kind of a model for oppression of all of us. So jumping back to the beginning of the book, I started with Danuta Soderman, who was a co-host of the 700 Club with Pat Robertson. And she was granted a bit of influence there. She could talk to the country. She could even preach sometimes. God forbid. But she also was bounded by certain rules. She could have this influence if she followed certain rules. And as soon as she didn't, as soon as she was a threat that Robertson needed to dispose of, she was gone. When I think about the SBC, and I think about just year after year, amendments like this come up, attempting to silence women after women have worked so hard to press SBC for reform on sex abuse. This is no coincidence. When I look at that trajectory, and there are still women in SBC, many are leaving, a lot of people have left SBC, I see women who are making some sort of compromise. And they're there, whether it's for comfort or community, or because they're too scared to leave and they know what they'll lose if they leave. They're making a deal, but they're eventually gonna lose. And I think that's the heartbreaking part of seeing what's happening now within that denomination. Is bad for the church. It certainly isn't good evangelism. But but it's also so bad for women who, the longer they stay and tolerate being treated like this, it breaks them down. And eventually the only way to safety is to leave.
Wow. Well, your book, Damned If She Does, when does it come out and where can people buy it?
September 15th, and everywhere. Everywhere we can get a book, you can buy a book there. It's going to be a big publication day. A bunch of other big books are coming out then. So I'm hopeful September is going to be a good month for dialogue about faith in America, especially in our current political situation.
Yeah. And your website?
sarahstancorp.com.
That's easy. And I will make sure all of this is in the show notes. And thanks again, Sarah, for stopping by and telling us about your book.
Thank you.
Awesome.